This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawar Namatanda.
I'm BJ Lamsal.
And I'm Jennifer Raphael. Today we're chatting with Kiri Parr. Kiri is an expert in construction law, procurement strategy and risk management. She has almost 3 decades of experience in the construction industry, first as a construction lawyer in private practice, then as general counsel for a large international professional consulting company. She's on the board of the Society of Construction Law Australia and the Dispute Resolution Board Foundation, and is a member of the FIDIC Contracts Committee and the Law Council of Australia's Construction and Infrastructure Committee. Kiri regularly writes and speaks about procurement strategy, risk management, human behaviour and governance models. She is also a senior fellow member at the University of Melbourne, delivering the course Major Project Delivery as part of the Master of Construction Law program. In this episode, we'll talk about culture in the construction industry, the structural drivers of dysfunction, and how we can change. Let's jump in. Kiri, welcome to the show.
Welcome. Hello.
It's great to have you here this morning. So we're going to dive into culture today, and specifically culture in the construction industry. There's been a lot of recent talk about our culture and more specifically some of the serious cultural problems facing the construction industry. But firstly, Kiri, when we talk about culture, what exactly are we talking about?
So culture is more about the way things are done around here. What are our practices and behaviours that influence how we do our jobs and how we interact with each other as human beings. It's very different from our technical practice as construction lawyers, but they're very, very related.
Absolutely. And one impacts the other and vice versa. And so it's really quite important for us to consider these issues, isn't it?
Yeah, absolutely. And it's interesting because about 10 years ago, I think I did my first sort of big presentation at SoCLA's national conference, and I talked about all the things that we've normalised in our business. I talked about the adversarial culture and our aggressive contracts and our lack of standardisation, all these things that we do without thinking that we've normalised. And I've attended just about every conference since then. And I see the same pattern emerging. I see a lawyer coming in 10 years. They've been trained how to be a construction lawyer in our industry. They've been trained to write great bespoke contracts. Like the D&C contracts are normal and are ideal in most circumstances. But they also come to this realisation that it doesn't work. We're not delivering better projects. We're not getting the outcomes that we want. And they struggle with the culture in the construction industry, which is aggressive. So I've just reached this point, and I think a lot of people see it, that you sit down and go, is this as good as it can get? And, the piece of work that I'm trying to work out is what is driving this culture in our construction industry? What is the role that the construction lawyers are playing? And where does change come from? And I'd be very firmly of the view that we're not going to get change from more construction law, which is why I'm sort of like the anti-construction law, because I'm going, we need to talk about things other than our construction contracts or think that another case or another clever drafting set of words is going to solve the problem. I'll use this terminology, change the trajectory of our industry.
Yes, sometimes it feels like this chicken and egg conundrum, doesn't it, where we talk about the contracts affecting culture, but it's the culture that also affects the contracts, and we get in this sort of circular cycle, and it's difficult to sort of get off that path, isn't it?
Yes, and what I hope is that we don't just sit in one or the other or think that there's some magic bullet. There is no single magic bullet. I do get worried when the only thing people look at changing is the culture, because I think structures drive culture, and there's a really good argument that structure drives culture. And The classic example in the construction industry is that over, for a very long time, but definitely in the Australian market it happened in the 80s and 90s. So if you're a younger listener, the world was not always as it is. We now have a market that's very much dominated by the design and construct model with its near neighbours sort of PPPs and construct-only models. And they've been drafted to shift a lot of risk, or we've normalised that we use these to shift risk and responsibility to the contractors and in quite adversarial ways. So it's not just we'll make you responsible, we'll make you responsible for everything that you couldn't possibly know about. So we call these very transactional contracts, and we've got a market that's dominated by them, but it's actually done some interesting things in market. So if you're going to run a successful business in a contract that's moved a lot of risk to you, you become very strong commercially. You build up your commercial skills. So those companies now value commercial adversarial skills over building skills, for example. It puts power and resources into those commercial skills as opposed to quality and safety. When things get difficult on a project, if you're at crunch points, there's a number of ways to go or a number of factors to consider. The two driving factors for financial outcomes for contractors in a D&C model is price and time. So because those are the two things that you are rewarded for in your contract, you are going to make decisions based on those two factors over everything else in the majority of cases, which is why 40 years on, we've got an industry that really struggles with quality and safety. We certainly haven't shifted the dial on those elements. And we have businesses that are unbelievably good at managing the commercial risks sitting in contracts.
It also has an effect on things like innovation, doesn't it? And creative ways that we can work together to manage problems within the industry. These sorts of, structural drivers that you're talking about really don't lend itself towards creativity or innovation.
I think my answer might be yes and no, because actually we've been unbelievably creative at solving the commercial conundrum of these contracts, right? We have the most amazing delay and quantum analysis. We've got some of the most interesting AI that I've seen that's coming into supporting our construction industry has been on managing time and cost risk. But yes, we've been really innovative of the problems we have to solve, which is it's a low profit market that has to deliver these projects with this very high level of risk. We're very creative in terms of using litigation to manage risk. But the counter side of that is there's very little in our system that rewards technical creativity, that rewards the ways you could get people coming together to deliver their projects more effectively or a more sustainable market. There's a classic story I can remember, one of the large contractors, and they were developing a low-carbon concrete. But it was a new product, it was new to market, and when the choice came of which jurisdiction would you roll this new product out on, the answer was not the Australian market, because the warranties that are sitting inside the contract are so adversarial that you won't take the risk of something going wrong. And because we've normalised these very adversarial contracts, and we've got this other long arc sitting in our industry which has de-scoped the owner capacity, or maybe rather than de-scoped, we've had a reduction in owners' technical capacity. If your view is I've outsourced all the risk, it allows you to look away from risk. You think you don't need the skills to understand the risks, which is the exact opposite of what you really do need. So if you've got this combination of owners who really struggle to understand project risks and to take decisions around it because they're risk adverse, they don't want to take on any risk, and the market's sitting there going, well, I have to take all of the risk of this and I can't engage in a technical risk-based conversation with an owner and try something out. You get less willingness. There's little reward for taking risk in our market. So when there's little reward, there's certainly very little profit reward, and if anything goes wrong, there's absolutely no reward. You suppress the willingness to try new things, to be creative, to do problem solving on our projects. And I think that's a real detriment that we see in our market.
And what role do you think that construction lawyers have to play in this in terms of, you mentioned the willingness of clients to understand risk and potentially to accept risk. Is there a role that construction lawyers have played in bringing this about?
Have we been playing a role? Yes, we have. And I'm going to throw in one of my influencing theories that sit behind some of my thinking. And this is an anthropologist's view. And it's an anthropologist called David Graeber. And he came up with a theory which was, he basically created 5 types of jobs that have emerged in our modern economies. And this is a big cultural piece, I suppose. And he did call them bullshit jobs. So there's 5 kinds of bullshit jobs: flunkies, goons, duct tapers, box tickers, and taskmasters. So unfortunately, most corporate lawyers and in-house lawyers, we sit in the category of goons, which is that we don't actually add value, but we're here because somebody else has the same kind of goon on their side. And if you can imagine, what do goons do? They stand in front of the citadel and protect it from all invaders. So your role as a corporate lawyer or an in-house lawyer is to sort of stand on the parapets of your business and try and protect it from all invaders. Now, when I started practicing construction law, or when I was an in-house lawyer, when I joined Arup, 20 years ago, there was probably 4 in-house lawyers in engineering firms at that point in time. You rolled forward 15 years when I left, and all of the big engineering firms had teams between 5 and 10 people. So our parapets, our companies became larger. Everybody started going, we need an in-house lawyer to do these negotiations. And your job, you exist because the other side has lawyers, and your job becomes to do everything you can to defend the legal entity or the corporation that you're a part of. And what a lawyer is really good. We're really good at thinking about everything that can possibly go wrong, because that's our training background. We are trained in failure. We're not trained in success. Think about your legal training. When were you ever trained into how to get things going well? Never. We have absolutely no mental models or philosophies for doing things well. So we are the goons. We're trained in risk. We carry our big gun, which is our contract, and we put everything in that contract that we think might protect our clients. And you can see us. We have internalized this role where we go, my number one role, I'm here to protect the client. Nothing can go, if I've got to write this contract, so nothing can go wrong. So we have internalized this view. I was talking to somebody the other week and they go, it takes a lot of intellectual rigor to write less in a contract. And I think that's a rigor that we've really lost because of how the market's evolved and the roles we're being asked to play. We're not being asked to do that intellectual rigor that's about, what can I take out of this contract? What does this contract not need? We are rigorously trained to think, I can solve every problem inside this contract, and my job is to try and move as much risk as I can. It's not giving us better outcomes, though. But we're sitting here going, we've convinced ourselves over, look, this has been the arc of my practice. I've seen us convince ourselves that these very bespoke, these very complicated contracts, that more lawyers will deliver better outcomes. And it's not the outcomes that we're getting, which is why I'm so passionate about going, we need to think about how our practice influences our industry, which I think circles us back to the question. So that would have you ask, what should construction lawyers be focusing on? I think we should focus on some very, very different questions, like if you're doing something highly dangerous, like building a bridge or a tunnel, because there are routine bridge failures, tunnel collapses, what kind of decision-making and quality control does your procurement model as a whole drive to manage that risk? And if you're in a D&C model, for example, and you've gone, this is great, the fundamental issue is at that point in time where you're moving your TBM that next metre forward and the geotech has a concern about some issue that might be emerging with the rock that they've been excavating, and they're going, hang on, I think we need to take some time to examine the data that's coming in, but it's not conclusive yet. There's some uncertainty. I can tell you the influences at that point in time in that contract model is not, is it safe to move, to keep on going forward? It's going, we can't afford to stop.
Mm.
And that will be the driving thinking. Now, it doesn't mean that in every time, the slower and the more important or the more difficult conversation won't happen. But in the majority of times, that time and cost drivers are going to be the dominant influences on the decision making.
They're going to trump everything else.
Yeah, and the client in most of these models has very little power to stop, because that's exactly what the model's designed to do. It's designed to go, this project is the contractor's risk. And this is one of the myths that we all share as lawyers. We think that we've moved the risk has been moved and that party will bear it. But there's so many examples of, if you get to some of these catastrophic events on your projects, that risk has not moved. It comes right back to the owners. But we kind of like to think that it won't, and that we have successfully moved that risk. But yeah, having open conversations at the beginning about what those catastrophic risks are and the actual capacity for another party to bear them.
Thinking about that rather than simply pushing off the risk entirely to one party.
Yeah. I'll take us on a slight side detour, because we all know that there are issues with the way projects are shaped and they come to market. They routinely go over budget over time and don't achieve their stated benefits. So there's a question about, why do we find it so difficult as human beings to plan these projects and to try and get plan for more reliable outcomes? And there's two behavioural scientists who are having a roaring debate. One of them's Daniel Kahneman. He wrote the Thinking Fast, Thinking Slow book, really well known. And he talks a lot about optimism bias. So as humans, if we're predicting how things will go in the future, we will be unduly optimistic about what it would take.
Look at things with rose-coloured glasses.
We do. And he uses an example in the book of writing an academic book, and they go, the four of us will be able to get it done in 2 years and it will be fine. And in reality, nobody's ever written a book in 2 years. It's always taken at least 4. But we don't want to tell ourselves that it'll be 4 years, because there's no way you can commit to 4 years. So there's optimism bias. We're just geared to do this as human beings. Otherwise, we wouldn't do anything at all. And then the other main behavioural scientist is Flervier. And Flervier says, no, it's just not optimism bias. What we have is strategic misrepresentation, which is us deliberately acting to meet the political needs to get the project up. Flervier will argue that we're not just optimistic, we're actually deliberate. We deliberately design our strategies to get these projects up. And they were having a raging debate about which one was at play. I think they ended up getting to the point of going, there's both things are at play.
I was going to say, yeah, it does seem like it would both at various points be at play.
Yeah, absolutely. I think that's right. We are both optimistic, but we also know what it takes to get a project up across the line. And those things are not what it takes to deliver a project well.
So turning now to our claims procedures that we have in these contracts, what role do you think it plays in potentially perpetuating dysfunction or affecting our culture in the industry?
So claims procedures, it's an interesting one. The first thing I'm going to say is that when we have problems on our projects, the claims procedures don't kick in until after that problem has crystallised, or after the problem has become big enough that someone has to fess up to it and make it pattern on a project. We're often incentivised not to tell people bad news. So the influence that what lawyers bring to the table in terms of claims, which is mediation, arbitration, litigation, they all kick in after the event. So we, as lawyers, become very focused on solving problems after the problems emerge. And that's our toolkit. And you'll never get rid of all problems on projects, but we're only of use after the project. What is, I think, could be more interesting for construction lawyers to focus on is what in your contract, what in your procurement model is going to work hardest to prevent that problem coming up in the first place. So we don't need more effort on the back end. We almost put too much effort on the mitigate the problem after it's emerged. What we really struggle to invest in is prevention. Understanding
being proactive.
What are the pathways to failure? What are we doing to manage those pathways? How effective are those controls or barriers the things that we put in place. How good is our regulatory system is a classic example of one that's played out in our market, because we do have a market that's got massive issues with building quality. We've got the reform that's happening in New South Wales that was led by David Chandler post the Opal Tower, where significant building defects emerged post-construction, post everybody had moved in. It's not a lone example. So what are in our system that are preventing these catastrophic events? And one of the things you need to prevent building failures is a really good regulatory system that is resourced, that has technical capacity, that is out overlooking building sites and calling out bad behaviours. And that weakened over the last 30 or 40 years. And I actually think it's one of the best things we've got going in the market right now is the strengthening of the regulatory frameworks. Now, some people are screaming blue murder over it, but if we want good outcomes, we need good builders who know how to build well and who are rewarded for building well, for building good quality buildings. And so it is, to me, the rebuilding of our regulatory capacity is a long-term strength, and I'm hoping it continues across the whole country. I mean, again, being in a state-based country, we'll go state by state, and we're going to have a lot of variety between those states, and that's probably just another element of the system that makes getting better outcomes even harder.
More challenging. It's something that potentially then will conflict with this idea at the moment of the need for less regulation, less red tape when it comes to our housing crisis and increasing productivity in the industry. There's been a lot of talk about that following the government roundtable and about reducing regulation. But what you're saying is that potentially doesn't lead to better outcomes in terms of the build quality.
That's right. And you talk to some technical people involved in the development of the Australian standards, and they will talk to how effective those standards are. And that's another part of our structure that's probably become weakened over the last few decades. So if the Australian standards and the National Construction Code aren't kept up to date with technical changes, with product changes that are happening, then again, we get poor outcomes. So there's been a proposition to freeze changes to the NCC for a decade. There's been questions about how effective Australian standards are about keeping their standards at a highest quality. The ACP issue or the aluminium composite panel issue is a classic example of how issues with those drafting, with the testing regimes inside the standards sort of allowed a product that wasn't up to scratch to come in and become very widely adopted across our market. And there's arguments about interpretation that allowed that to happen. And that's, to me, where the system as a whole sort of interacts to lead us to those bad outcomes. So if you want reliable, good quality products coming into market, those standards need to be very well drafted. They need to be kept up to date. When issues emerge, you need the opportunity to fix them, to improve them, to not allow weaknesses to sit in them. There's an amazing book on the aluminium composite panel issue as it played through in London. It's called Show Me the Bodies. And they talked about the direct relationship. They showed the direct relationship between government wanting to suppress changes to red tape. We can't have more red tape. And it led to a weak wording that allowed a really poor product to stay in market for a very, very long time, because everyone was scared of, well, we can't suggest a change, we can't allow a change through our system. So the argument I have is that the health of our construction industry is a function of how healthy our regulatory bodies are and how healthy are the guidelines, the regulations that shape our industry. And so if these fundamental building blocks aren't functioning well and if they're weak, then
it has a flow-on effect. It
has a flow-on. It creates a weakness in the overall system. And so once you have a system that has a whole series of weaknesses, you end up with an industry as a whole that is struggling to really drive better outcomes, improve its productivity, achieve all those other goals that we say are good.
So what do we do? How do we change? How do we solve this problem?
Well, there are things that we can do. One is understanding that it's not one thing, it's not a silver bullet. We're a system, we're as good as the capacity of our clients, we're as good as the contracts that we're drafting, we're good as the procurement models. So all of those things are interacting to give us the outcomes. So the area of science, and this is the nerdy part, I suppose, there is absolutely an area of science that's starting to tackle how you understand systems and how you deliver more reliable outcomes in these systems. The area of science is called complex systems theory, and you'll hear people talk about complexity, complex systems, complex science. And it's a relatively new area of science, and it's relatively new in the context of it's been around for 50 or 60 years, as opposed to Sir Isaac Newton's theory or Newtonian theory, which is reductionist, which is we understand the world by breaking it down into its parts and finding the broken parts. So that's been around for 400 years. Our institutions are designed this way, how we think, how we organise ourselves. It's very much reductionist. Like the world's like a watch sitting in its watch case. I can open it up, look at it, find broken parts, fix the broken parts, put it back together. And we almost do not understand the extent to which that kind of thinking has shapes our legal industry. Like causation assumes Newtonian theory. It assumes that we can break something down into its parts and find the broken part and assign blame. Principles of negligence. Is a duty of care owed? Has that duty been breached? Has it caused the loss? It's Newtonian.
So how is complex systems theory different then? Does it look at things from a more holistic perspective?
Yeah, that's what it's starting to do. And while the first area of practice of this was proving that complex systems existed, we've now moved past that point. And what I'm really interested in is in a suite of theories that are emerging about how you get more reliable outcomes. Now, they're not used in the construction industry, but I think there's some really interesting theories that are emerging and can easily be applied. So the first one is something called high reliability organisation theory. It was a group of scientists 30 or so years ago looking at nuclear industry, airline industry, going, what is different about them? What do they do that delivers better outcomes? So if you were to take some principles of HRO theory, there's 5 principles that is behind HRO theory. So they say if you want more reliable outcomes, you've got to work out how to do these 5 things. 1, you have to be preoccupied with failure. You have to be constantly thinking about what's going to go wrong and how to prevent it.
As opposed to having a more optimism bias like we were talking about before, looking at things through rose-coloured glasses.
Yeah, and not just focusing on the opening night or how shiny and bright it's going to be. You've got to be paying attention to all the things that are going wrong. Combine that with you don't just look at big highlight numbers, summaries. You've actually got to really get to the detail of things because the reality of it sits in the detail and getting to the real stories that are going on inside a system. And the classic example there might be health and safety data. So if you only look at top-level numbers or summaries, you might not be understanding what's really happening. The third principle is called sensitivity to operations, which is you're paying attention to how things are actually being done on the ground. Fourth principle is commitment to resilience, which is how do you come back from problems or failures? And I think we have a real problem with that in our construction industry, with our contracts. They allocate blame, but they give us so few pathways to come back together and to keep on delivering the project. And the fifth principle is deference to expertise, which is who actually knows the most about how to get this thing done. It's not the financial person sitting in the back office or the lawyer. It could be the person on the front line who's operating that piece of equipment, who knows more than anyone else about the expertise of doing that particular task. So that's HRO theory. And I like those 5 questions because if I ask those 5 questions, I start thinking differently about procurement models, procurement systems, how I'd write a contract that supports each of those 5 principles. The second one I really like is something called causal mapping, which asks you to map out your system and to look for the interactions and to look for what outcomes are emerging from that system and the interactions between the system. The Cynefin framework is really good for understanding what kind of system you're in, and that's led by a researcher called David Snowden, and I follow his work as well. So what we have is a suite of tools that are now emerging that acknowledge that we are not in a Newtonian world, we're in a complex world, and that actually allow you to sit down and drive better outcomes. The other flip side, because we were talking about the behavioural sciences before, so Fleuvier's book, How Big Things Get Done, He's got 10 principles that are all about trying to tackle behavioural norms of we're human. We really need our heuristics and our shortcuts. His argument is for some better shortcuts that we could adopt. So we've got all those, the behavioural science, and if you go back to Kahneman's thinking fast, thinking slow, how could you build slow thinking into the design of your construction contract? You know, the pattern is the client calls you up, I need the contract next week. You pull your contract off from your shelf, you change the two things that the client tells you are different, and you kind of stop there. So how do you create patterns that allow you to think differently about what this contract needs to be and what needs to meet the needs of this particular project or program? And the kind of thinking that I really encourage everyone to do is we often think about what does this contract need to do for this project? So we're doing single game theory, right? How do I maximize the outcome for me on this game? And we don't think about what is the cumulative effects of playing the game the same way over and over and over again. So if you want to change your system, you might want to go, well, what do I need to change now that will influence my system over the next 10 projects, 20 projects that I roll out? And so having that macro view, that longer term view about what you might achieve over time, it's ways of changing your perspectives on what you can do inside your contract, and changing how you might think is the right thing to do. So, for example, if you're going, I want my market to know that we'll be using standardized contract forms and you can invest over time in tools because we'll not be changing the game every single project, that could be a valuable thing to start introducing at some point in time. So there you go, the complex systems and behavioural science. And I might make the last point is that I don't think this thinking is particularly new. I've been studying a little bit of Indigenous law as well, and the lessons are very, very similar. That the lessons of we need to come together slowly, we need to get to know each other, we need to understand each other and learn about each other in order to have a successful relationship. We need to have this concept of how do we return together? How do we restore balance after conflict? That's the camerata concept, which is really fascinating. And I would think as an industry, we never stop and think about, and this is a weakness in how we think about disputes. We think about the disputes, but we never go, well, what does it mean? How do we come back together? How do we keep on delivering this project together? Which is a really powerful piece of thinking that kind of ties everything up.
So you mentioned these theories, these ways of thinking, the behavioural science, complex systems, they've all been around for a long time and we haven't really been applying them to the construction industry. Do you think that's because there's this, I guess, kind of culture of complacency, a culture of this is just the way the industry is, we can't change it, this is how it is?
That is one of the, you can hear people, they will say that, won't they? They'll also tell you late at night after a few drinks how desperately unhappy they are. I don't think it's just the construction industry. I think it's a little bit of our Western culture. It really does reward and entrenches the current norms, the pursuit of profit over everything else. So at a big macro societal level, in a country like Australia, that's a hard thing to shift, and the construction industry is not solely responsible for it. That said, I have more imagination than that. I hope many of the listeners do too. I have been told to just accept that this is the way business is, but I can imagine a better world. I know a lot of people in our industry who can imagine a better world, and there are ways to get there. Let me ask everyone to imagine a different world and have a different conversation. We build our own world. We are capable of building our own worlds. The light at the end of the tunnel that I currently see is this conversation about collaborative contracts, not because it's a contract, but because it's a model that allows us to bring more of this thinking to the table and to implement it. And what I see are some amazing project directors and organisations who are bringing this thinking into practice on projects. It's not every project, it's not every day. It's more the exception than the rule right now, but it's becoming more widely known, more widely talked about. This is a conversation that wasn't happening 5 years ago. We weren't talking about behavioural science. We weren't talking about complex systems theory. We weren't talking about anthropology or any of the other, those long-term, learning that sort of slowly takes a while to get things from an academic world into how does it change our practice day to day on projects. But I am starting to see more learning, more teaching in this space. So having studied it, we're going through that learning phase, and with the next phase is to actually work out how to adopt them and roll these practices in our projects. So I am seeing it happen. And what you notice is that the people who do have this much broader mindset about project delivery, they're having more powerful conversations. They're driving some really interesting benefits on their projects, and they're human benefits. They're about how we work together as people, and those are the projects that are going to attract the people, the staff. Those are the projects where the imagination, the creativity is going to happen on. Those are the projects where we will get to the end of the projects and maybe not spend 10 years in courts and give a lot of money to litigation lawyers and claims consultants.
So there's hope for us.
Oh, there's always hope.
Well, on that optimistic and positive note, that might be a good place to end the conversation. So, Kiri, thanks so much for joining us on the show.
Thanks.
That was construction lawyer and industry commentator Kiri Parr. Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to their website, scl.org.au. This show was produced with strategy and production support from Sound Cartel.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Mawuna Matanda.
I'm Bijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.